Substantive law, a part of law which creates, defines, or regulates rights concerning life, liberty, or property, or the powers of agencies or instrumentalities for the administration of public affairs. Primicias versus Ocampo. Procedural, adjective, or remedial law prescribes the method of enforcing rights or obtaining redress for their violation. Bustos versus Lucero. Sources of remedial law: the Constitution, laws creating the judiciary, laws defining and allocating jurisdiction to different courts, rules promulgated by the Supreme Court, circulars, administrative orders, internal rules, and Supreme Court decisions. Scope of remedial law: Constitution, Civil Procedure, Rule 1 to 56, and other related laws. Provisional remedies, Rules 57 to 61. Special civil actions, Rule 62 to 71. Special proceedings, Rules 72 to 109. Criminal procedure, Rules 110 to 127. Evidence, Rules 128 to 133. Katarungang Pambarangay Law, RA 7160, and implementing rules. Revised rules on summary procedure, rules on small claims case, rules on environmental cases. Judicial power includes the duty of the Court of Justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Section 1, Article 8, 1987 Constitution. The power of judicial review is the Supreme Court's power to declare a law, treaty, international or executive agreement, presidential decree, proclamation, order, instruction, ordinance, or regulation unconstitutional. Basic concepts in remedial law. Court. There is a table, a gavel, there is someone sitting there. Then below, there are lawyers sitting down, but actually, what is described is a courtroom and not a court. Similarly, when you are asked to describe a corporation, you will refer to the building, the office, the employees. But a corporation, as you know in person, is a juridical entity. It is a creature of the law. It is a person under the law. But it has no physical existence. A court has no physical existence, only a legal one. What is a court? A court is an entity or body vested with a portion of the judicial power. Lontok versus Batung. Why portion only? This is because the Constitution provides that the judicial power shall be vested in one Supreme Court and in such other lower courts as may be established by law. Article 8, Section 1 of the Constitution. So, the reason that the law creates different courts is to divide the cases or judicial power among them so that one court may not be burdened with so many cases. So judicial power is not exercised only by one court, but by several courts. There is a division of labor, and this division is done through delineating jurisdiction among courts. Jurisdiction will be discussed in the following parts. Judge. Just as corporations cannot act without its officers, a court cannot function without a judge. But do not say that the court and the judge mean the same thing. The judge is the person or office who presides over a court. Distinguish court from judge. The following are the distinctions. 1. Court is the entity, body, or tribunal vested with a portion of the judicial power, while judge is the person or officer who presides over a court. Judges are human beings. They die, they resign, they retire. they may be removed. The court continues to exist even after the judge presiding over it ceases to do so. In the Supreme Court, for example, the justices presiding over it are not the same justices who presided it in the early part of this century, yet the court in some decisions states that, as early 1905, we have already ruled such as such. Why do they use we? They are talking about the court. They are not talking about themselves. The court is continuous. It does not die alongside with the justices who presided on it. 3. The two concepts may exist independently of each other, for there may be a court without a judge, or a judge without a court. Pamintuan versus Lorente. Hearing and trial. Hearing is not synonymous with trial. The words hearing and trial have different meanings and connotations. Trial may refer to the reception of evidence and other processes. It embraces the period for the introduction of evidence by both parties. Hearing, as known in law, is not confined to trial, but embraces the several stages of litigation, including the pre-trial stage. A hearing does not necessarily mean presentation of evidence. It does not necessarily imply the presentation of oral or documentary evidence in open court, but that the parties are afforded the opportunity to be heard. Republic versus Sandigan Bayan. Hierarchy of the courts. In the 1996 bar, one of the questions in remedial law was state the hierarchy of the courts in the Philippines. Regular courts, Supreme Court, Court of Appeals, Regional Trial Courts. METC, MTCC, MTC, MCTC. No. METTC in Manila, MTCC cities outside Manila, Cebu, Davao, MTC municipalities such as Mindanao, Argao, MCTC circuitized areas because it is impractical and expensive to maintain one MTC in every municipality. Special courts. There are also special courts which are also considered part of the judiciary. These are Courts of Tax Appeals, Sandigan Bayan, PD 1486 as amended, Sharia District Courts and the Sharia Circuit Courts, PD 1083, also known as the Code of Muslim Personal Law. Number 4. Family Courts. Policy of Judicial Hierarchy. This policy means that a higher court will not entertain direct resort to it unless the redress desired cannot be obtained in the appropriate courts. While it is true, for example, that the Supreme Court, Court of Appeals, and the regional trial courts have concurrent original jurisdiction to issue writs of certiorari, prohibition, mandamus, such concurrence does not accord litigants unrestrained freedom of choice of the court to which the application for the writ may be directed. The application should be filed with the court of lower level unless the importance of the issue involved deserves the action of the court of the higher level. Classification of courts in general. Generally, courts may be classified as 1. Constitutional and statutory courts, superior courts and first-level courts, inferior courts. 3. Courts of original jurisdiction and courts of appellate jurisdiction. 4. Civil courts and criminal courts. 5. Courts of law and courts of equity. 6. Courts of record, probate courts, land registration, ecclesiastical courts, military courts. Constitutional courts versus statutory courts. Distinguish. Constitutional courts are created directly by the Constitution itself, while statutory courts are created by law or by the legislature. The first cannot be abolished by Congress without amending the Constitution, while the second can be so abolished by just simply repealing the law, which created them. In our country, there is only one constitutional court, the Supreme Court. Even the Sandigan Bayan is not considered a constitutional court because it was not created by the Constitution directly. The 1973 Constitution, particularly Article 13, Section 5, ordered the then National Assembly to create a special court to be known as the Sandigan Bayan, which shall have jurisdiction over criminal and civil cases involving graft and corrupt practices, and such other offenses committed by public officers and employees, including those in government-owned or controlled corporations, in relation to their office as may be determined by law. It was law that created the Sandigan Bayan PD 1486. The CA, RTC, and the MTC are created by the Congress. So there is only one constitutional court. All the rest, from the CA down and all other special courts, are only creatures of Congress. In political law, the power to create carries with it the power to abolish. That is why BP 129 abolished all existing courts at that time, CFI, CA, juvenile and domestic courts, etc. And RTC, IAC, MTC were created. That was the judicial reorganization of 1980 under BP 129. But there is only one court which the Batasan Pambansa could not touch, the Supreme Court. Superior Courts versus First-Level Courts. Superior Courts, otherwise known as Courts of General Jurisdiction, are those which take cognizance of all kinds of cases, whether civil or criminal, and possess supervisory authority over lower courts. They refer to these courts which have the power of review or supervision over another lower court. Inferior courts, otherwise known as courts of special or limited jurisdiction, are those which take cognizance of certain specified cases only. They are those which, in relation to another, are lower in rank and subject to review and supervision of the latter. What courts are superior or inferior? It depends from what viewpoint you are looking at. If you are looking from a viewpoint of the Constitution, there is only one superior court, the Supreme Court. From the viewpoint of other laws, the Court of Appeals may be inferior to the Supreme Court, but it is a superior court, for it exercises supervision over RTC, in the same manner that RTC might be inferior to the Supreme Court and the CA, but it has also power of supervision over MTC. The jurisdiction of the RTC is varied. It is practically a jack of all trade. The RTC has also the power of supervision over MTC. A superior court may therefore handle civil, criminal cases, while an inferior court may try specified cases only. The Supreme Court, CA, including the RTC, are considered as superior courts. The MTC is a first level or inferior court, so that its powers are limited to specified cases. It does not have any supervisory authority over any lower court. Original versus appellate. Original courts are those where a case is originally commenced, while appellate courts are those where a case is reviewed. Valentin's Law Dictionary. So if you are filing a case for the first time, that case is filed in an original court, but the case does not necessarily end there. You may bring the case to the appellate court, which has the power to change the decision of the original court. Is the Supreme Court an original or appellate court? The Supreme Court is both an original and an appellate court. The Supreme Court has original jurisdiction on cases of certiorari, prohibition, mandamus. There are certain cases where one may file directly to the Supreme Court. Is the CA an original or appellate court? The same is true with the CA. It is both original and appellate court. Section 9, BP 129. When we study the jurisdiction of the CA, you will see that it is both an original and an appellate court. There are cases which are elevated to it from the RTC, but there are also cases which are filed there for the first time, like an action for annulment of an RTC judgment. How about the RTC? Is the RTC an original or appellate court? The RTC is also both original and appellate court. You can file certain cases there for the first time, and there are also decisions of the MTC which are appealable to the RTC. How about the MTC? The MTC, however, is a 100% original court. It is the lowest court in the hierarchy. There are no cases appealed to it. There is no such animal as barangay court. The barangay captains do not decide cases. They only conciliate. Civil courts versus criminal courts. Civil courts are those which take cognizance of civil cases only, while criminal courts are those which take cognizance of criminal cases only. All the courts in the Philippines are both civil and criminal courts. They can handle both types of cases. The Supreme Court decides civil and criminal cases. The same is true with the CA, RTC, and MTC. So in the Philippines, there is no such thing as 100% criminal court or civil court. During the 70s, there was the Old Circuit Criminal Court. As the name implies, it is purely a criminal court, but with other courts, this was abolished by BP 129. With the abolition of these special courts, all their powers were transferred to the present RTC. Right now, there is no such thing as a 100% civil court or a 100% criminal court. So all our courts are both civil and criminal courts at the same time. Courts of law versus courts of equity. Courts of law are tribunals administering only the law of the land, whereas courts of equity are tribunals which rule according to the precepts of equity or justice and are sometimes called courts of conscience. Valentin's law. Courts of law dispose cases according to what the promulgated law says, while courts of equity adjudicate cases based on the principles of equity. Principle of equity means principles of justice, fairness, fair play, or of what is right and just without incurring into the terms of the statutes. Are the Philippine courts courts of law or courts of equity? Do they decide cases based on what the law says or based on the principle of justice and fairness? Well, in the Philippines, our courts, original or appellate, are both courts of law and of equity. U.S. versus Tamparong. In the case of substantive law, there is a thin line which divides the principle of law from the principle of equity, because principles of equity are also found in the principles of law. Equity is what is fair and what is just and equitable. Generally, what is legal is fair. As a matter of fact, under the Civil Code, when the law is silent, you decide it based on what is just and fair. Thus, the saying equity follows the law. In the Philippines, you cannot distinguish sometimes the principle of law and the principle of equity, because principles of equity are also written in the law. Example, the principles of Estoppel, laches, or solution in debiti are no longer purely principles of equity, since they are also found in our law. Under the Civil Code, when there is no applicable law, courts still have to decide according to customs and general principles. So what is estoppel? Estoppel is an equitable doctrine, which means that it is not fair that you disown your own representation after misleading somebody. But if you look at the Civil Code, there is a chapter on estoppel. So if you apply estoppel, you cannot say that you are applying a principle not found under the law. How about laches? It is considered to be the half-brother of prescription, because it means if you delay a certain right, then you must have no right. That is more of equity rather than of law. Solutio in debiti. No one should enrich himself at the expense of another. That is the principle of equity, but if you look at the Civil Code, it's there. Alonso versus IAC held. The question is sometimes asked in serious inquiry or in curious conjecture, whether we are a court of law or a court of justice. Do we apply the law even if it's unjust, or do we administer justice even against the law? Thus queried, we do not equivocate. The answer is that we do neither, because we are a court both of law and justice. We apply the law with justice, for that is our mission and purpose in the scheme of our republic. Courts of record. Those whose proceedings are enrolled and which are bound to keep a written record of all trials and proceedings handled by them. RA 6031 mandates all MTCs to be courts of record. Probate courts, those which have jurisdiction over settlement of estate of deceased persons. Land registration courts, those which have jurisdiction over registration of real properties under the torrents system. Inherent powers of the court. Before we leave the concept of courts, we must know that the courts of justice have what we call inherent powers, just like the state have certain inherent powers, namely police power, power of taxation, and power of eminent domain. Their very existence automatically necessitates the existence of these powers. So what are the inherent powers of the court? Section 5, Rule 135 of the Rules of Courts provide. Inherent powers of court. Every court shall have the power: A. To preserve and enforce order in its immediate presence. B. To enforce order in proceedings before it, or before a person or persons empowered to conduct a judicial investigation under its authority. C. To compel obedience to its judgments, orders, and processes, and to the lawful orders of a judge out of court in a case therein. D. To control, in furtherance of justice, the conduct of its ministerial officers and of all other persons in any manner connected with a case before it, in every manner appertaining thereto. E. To compel the attendee of persons to testify in a case pending therein. F. To administer or cause to be administered oaths in a case pending therein, and in all other cases where it may be necessary in the existence of its powers. G. To amend and control its process and orders as to make them conformable to law and justice. H. To authorize the copy of a lost or destroyed pleading or other paper to be filed in use instead of the original, and to restore and supply deficiencies in its records and proceedings. Situation. Suppose I have a power to decide and render a decision. I want to enforce the decision. How do I enforce? Well, usually the law provides for the procedure. But suppose the law does not provide for any manner to enforce. For example, a judge has rendered a decision, and the law is silent on how to enforce it. Do you mean to say that the order is unenforceable because the law is silent? No. Section 6 of Rule 135 answers the question. Means to carry jurisdiction into effect. When by law jurisdiction is conferred on a court or a judicial officer, all auxiliary writs, processes, and all other means to carry it into effect may be employed by such court or officer, and if the procedure to be followed in the exercise of such jurisdiction is not specifically pointed out by law or these rules, any suitable process or mode of proceeding may be adopted which appears conformable to the spirit of said law or rules. What Section 6 is trying to say is that when courts have the power to decide, they have the power to enforce. And if the law is silent, judges have to think of how to do it provided they conform to the spirit of the rule. So they should not make the order unless simply because there is no rule. That is part of their power. Enforceability of court writs and processes. Another provision that should be emphasized is Section 3 of the interim rules. Say the Court of Cebu issues a writ of or a process. Can that writ or process be enforced in Manila? What is the extent of the enforceability of a writ issued by a court. Under Section 3, Interim Rules, Writs and Processes. A. Writs of certiorari, prohibition, mandamus, quo warranto, habeas corpus, and injunction issued by a regional trial court may be enforced in any part of the region. B. All other processes, whether issued by the RTC or MTTC, MCTC, and MTC, may be served anywhere in the Philippines, and the last three cases without a certification by the judge of the RTC. Under Section 3 of the Interim Rules, you have to distinguish what kind of writ or process you are talking about. If it is a writ of certiorari, prohibition, mandamus, quo warranto, habeas corpus, injunction, it can be enforced anywhere within the region. So at least RTC can enforce it within the region, and it cannot enforce those writs outside the region. Example, if you are illegally detained, you can ask the court to issue a writ of habeas corpus. Now, a person is detained in Cagayan de Oro, and the family is here in Cebu City. They filed a petition for habeas corpus here in Cebu City. Is it proper? No. Cebu City belongs to the 7th Judicial Region, while Cagayan de Oro is in the 11th or 12th Judicial Region. The law is very clear. Writs of certiorari, prohibition, mandamus, quo warranto, habeas corpus, and injunction issued by a trial court may be enforced in any part of the region. Letter B. Section 3 further says, all other writs are enforceable anywhere in the Philippines. Suppose the MTC issues a warrant of arrest for the accused in the criminal case, and he fled to Baguio City. Such warrant can be enforced. This includes summons, writs of execution, or search warrants. Aspects of remedial law. There are two aspects of remedial law: public aspect, one which affords a remedy in favor of the state against the individual, example, criminal procedure, or in favor of the individual against the state, habeas corpus, on the other hand. Private aspect, one which affords a remedy in favor of an individual against another individual, like the rules on civil procedure, Gamboa's Introduction to Philippine Law, 6th edition. Brief history of the law on civil procedure in the Philippines. The origin of our law on procedure is American. Forget the law on procedure during the Spanish regime, but the first known ancestor of the law on civil procedure was the Old Act 190, otherwise known as the Code of Civil Procedure, which was enacted on August 7, 1901 by the United States and Philippine Commission. And that was the law until 1940, because on July 1, 1940, the Supreme Court enacted the Rules of Court, which we now call the Old Rules of Court, that continued for another 24 years until January 1, 1964, when the Supreme Court enacted the revised Rules of Court, repealing the old Rules of Court, and that continued for another 33 years until July 1, 1997, when the Supreme Court enacted, which took effect on that day, July 1, 1997, the new rules on civil procedure. Sources of the 1997 Rules of Civil Procedure. Well, of course, the sources are almost the same as the prior law. The old Rules of Court is also a source. Many provisions were taken from the 1964 rules, substantive law like the Civil Code and the jurisprudence, and of course Supreme Court circulars. Many circulars are now incorporated under the new rule, so those are the main sources. Like, previous rules of court, jurisprudence, new Civil Code, Supreme Court circulars, rule-making power of the Supreme Court. The Rules of Court 1940, 1964, and 1997 have all been enacted by the Supreme Court. It is law, not enacted by Congress, but enacted by the Supreme Court. What is the authority of the Supreme Court to enact a law when actually the role of the judiciary is only to interpret the law? Is this not a violation of the separation of powers? The authority of the Supreme Court in enacting the prior rules and the present rule is what you call its rule-making power, which provision was found in the 1935, 1973, and 1987 constitutions. Based on the present law, the rule-making power of the Supreme Court is expressed in Article 8, Section 5, Paragraph 5, which is substantially the same as the 1935 and the 1973 Constitution, which states that the Supreme Court shall promulgate the rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts. Limitations to the rule-making power of the Supreme Court. The Constitution has also placed limitations on these powers. As currently worded, one limitation provided for by the article is the rules of procedure to be enacted by the Supreme Court shall provide for a simplified and inexpensive procedure for the speedy disposition of cases. The second one is the rules shall be uniform for all courts of the same grade. And the third is the rules shall not diminish, increase, or modify substantive rights. That's the limitations. Let us summarize. 1. The rules of court shall provide a simplified and inexpensive procedure for the speedy disposition of cases. 2. The rules of court shall be uniform for all courts of the same grade. And 3. The rules of court shall not diminish, modify, or increase substantive rights. Substantive rights are created by substantive law, so that the rules of procedure should not increase, diminish, or modify them. In effect, the rules of court should not amend the substantive law. It can only interpret substantive law, but should not change it completely. Those are the limitations. With that, we are now ready to tackle the 1997 Rules on Civil Procedure. Jurisdiction in general. The word jurisdiction is derived from two Latin words, juris, law, dico, to speak, or to say. So in effect, when you say jurisdiction, literally translated, it means I speak by the law. It means that you are saying, I speak with authority, because when you invoke the law, then your act is authorized. So when you say, I speak by the law, you mean, I will do it in the name of the law. It connotes authority or power. So jurisdiction implies authority or power to act. But what act or acts is or are authorized? If we relate jurisdiction to courts, it means authority or the power to hear, try, and decide a case. So, jurisdiction means the power or authority of the court to hear, try, and decide a case. In this complete aspect, jurisdiction includes not only the powers to hear and decide a case, but also the power to enforce the judgment, as the judgment or decree is the end for which jurisdiction is exercised, and it is only through the judgment and its execution that the power of the court is made efficacious and its jurisdiction complete. The power to control the execution of its decision is an essential aspect of jurisdiction. It cannot be the subject of substantial subtraction, and the most important part of the litigation is the process of execution of decision. Echegaray versus Secretary of Justice. Test of jurisdiction. Since jurisdiction refers to power or authority to hear, try, and decide a case, it cannot depend on the correctness or rightfulness of the decision made. Century Insurance Company versus Fuentes. Correctness or rightfulness of the decision relates to the exercise of and not of the authority itself. The test of jurisdiction is whether the court has the power to enter into the inquiry and not whether the decision is right or wrong. Herrera versus Barreto. Duty of the court to determine its jurisdiction. It is the duty of the court to consider the question of jurisdiction before it looks at other matters involved in the case. It may and must do this on its own motion without waiting for the question of jurisdiction being raised by any of the parties involved in the proceeding. Courts are bound to take notice of the limits of their authority, and they may act accordingly by dismissing the action, even though the issue of jurisdiction is not raised or not even just suggested by counsel. Ace Publication versus Commissioner of Custom. What is the effect if the court has no jurisdiction, or of absence or lack of jurisdiction? Well, if the court has no jurisdiction, it has no power or authority to try a case, and because it has no authority, it must not exercise it. Exercise of absent authority or power is necessarily nothing. Thus, without jurisdiction, the entire proceedings would be null and void. The only recourse for the court absent jurisdiction is to dismiss the case motu proprio, or on motion, for without authority it cannot act. What about if it has jurisdiction? It is the duty of the court to exercise the jurisdiction conferred upon it by law, and to render a decision in a case properly submitted to it. Failure to do so may be enforced by way of a mandamus proceeding. Constitutional guarantee of access to courts and jurisdiction. The constitutional guarantee of access to courts refers to courts with appropriate jurisdiction as defined by law. It does not mean that a person can go to any court for redress of grievances, regardless of the nature or value of his claim. Santos III versus Northwest Airlines. Jurisdiction versus exercise of jurisdiction. Jurisdiction pertains to the authority to hear and decide a case. Any act of the court pursuant to such authority, including the decision and its consequences, is exercise of jurisdiction. The authority to decide a case, not the decision rendered, is what makes up jurisdiction. It does not depend upon the regularity of the exercise of that power or upon the rightfulness of the decision made. Where there is jurisdiction over the person and the subject matter, the resolution of all other questions arising in the case is but an exercise of jurisdiction. Herrera versus Barreto. Why is it important to distinguish jurisdiction from exercise of jurisdiction? Well, definitely, a court acting as such may commit errors or mistakes and questioned later before a higher court. The procedure or remedy in case of a mistake or error would be dependent on whether it is an error of jurisdiction or an error in the exercise of jurisdiction, also known as error of judgment. Example, a case of murder was filed in the MTC. The accused can, sir, files a motion to quash because MTC has no jurisdiction over cases of murder, but the court denied the motion to quash, meaning the judge has decided to assume jurisdiction. What is the error committed? When the court without authority assumes authority over the case, that is called error of jurisdiction, the court committed an error of jurisdiction. Suppose the case for murder is filed in the RTC, where the court has jurisdiction. But in the course of the trial, it committed mistakes like the court misinterpreted or misapplied the provision of the RPC or the intermediate sentence law. What error is committed? Obviously, the RTC has authority to hear and decide the case and therefore acted with authority or jurisdiction. There is no error of jurisdiction. However, in the exercise of such authority, it committed a mistake. Thus, the error committed is error in the exercise of jurisdiction, also known as error of judgment. Is the proceeding null and void then? No. What is committed is an error in the exercise of jurisdiction. And if not corrected, the error can become final and executory. In other words, if not objected, it will stay. To distinguish, when a court acquires jurisdiction over the subject matter, the decision or order on all other questions arising in the case is but an exercise of jurisdiction. Errors which the court may commit in the exercise of such jurisdiction, like errors of procedure or mistakes in the court's findings, are merely errors of judgment. Whereas, when a court takes cognizance of a case over the subject matter of which it has no jurisdiction, or acts in excess of jurisdiction, or with grave abuse of discretion amounting to lack of jurisdiction, the court commits an error of jurisdiction. GSIS versus Olisa. Number 2. When the court acts without authority, error of jurisdiction, such act would be null and void, or at least voidable. But if the court has authority but commits a mistake in the exercise of such authority, error of judgment, such mistake will bind unless corrected. Number 3. Errors of jurisdiction are reviewable by the extraordinary writ of certiorari, whereas errors of judgment are reviewable by appeal. An error of judgment should be raised on ordinary appeal, not by certiorari, because certiorari is only confined to correcting errors of jurisdiction or grave abuse of discretion. The governing rule is that the remedy of certiorari is not available when the remedy of appeal is available, or even if available, when it will not be a speedy and adequate remedy. And when the remedy of appeal is lost, you cannot revive it by resorting to certiorari, because certiorari is not a substitute for the lost remedy of appeal. Lack of jurisdiction and excess of jurisdiction. They are distinguished thus. The respondent court or tribunal acts without jurisdiction if it does not have the legal power to determine the case, where the respondent, being clothed with the power to determine the case, oversteps its authority as determined by law. It is performing a function in excess of its jurisdiction. Vit Industrial Sales Company versus Cheng. Examples of excess of jurisdiction: when the court does not conduct a pretrial conference, which is mandatory under the rules. To whom is jurisdiction vested? Jurisdiction is vested in the court, not in the judge. A court may be a single sala or may have several branches, multiple sala. If the latter, each is not a court distinct and separate from the others. So when a case is filed before a branch, the trial may be had, or proceedings may continue before another branch or judge. Tagumpay versus Morcoso. Say the RTC of Cebu City is composed of several branches, 22 all in all, but technically there is only one court, the RTC of Cebu City. Now, if the case is filed and assigned to branch 8, can that case later be transferred and continued in branch 9? Yes, because you never left the same court. You are still in the same court. This is because jurisdiction is not with the judge, it is with the court itself. But there is only one branch of RTC Bogo. Can RTC Cebu City take jurisdiction over its case? No, because they are different courts and jurisdiction is attached to the court. Types of jurisdiction. 1. Based on cases tried, general jurisdiction and special or limited jurisdiction. 2. Based on the nature of the cause, original jurisdiction and appellate jurisdiction. And 3. Based on the nature and extent of exercise, exclusive jurisdiction and concurrent or coordinate jurisdiction. Number 4. Based on situs, territorial jurisdiction, and extraterritorial jurisdiction. General jurisdiction and special or limited jurisdiction. General jurisdiction is the authority of the court to hear and determine all actions and suits, whether civil, criminal, administrative, real, personal, or mixed. It is very broad to hear and try practically all types of cases. B. Special or limited jurisdiction is the authority of the court to hear and determine particular cases only. Its power is limited. Example, in criminal cases, the MTC has jurisdiction over offenses where the penalty imposable does not exceed 6 years, while beyond 6 years, they are triable before the RTC. If you examine the jurisdiction of the MTC, it has a limit but none for the RTC. Original jurisdiction and appellate jurisdiction. Original jurisdiction is the power of the court to take cognizance of a case at its inception or commencement. Appellate jurisdiction is the power vested in a superior court to review and revise the judicial action of a lower court. If the court has the power to correct the decision of a lower court, the power of this court is appellate. This is because it is commenced somewhere else and it is just reviewing the decision of the said lower court. Note that in certiorari petition, the action of the superior court is not to correct but to annul. The power exercised by the superior court is the power of control and supervision over an inferior court, not appellate, that is, to limit the inferior court within its jurisdiction, its authority. Exclusive jurisdiction and concurrent or coordinate jurisdiction. Exclusive jurisdiction is that possessed by a court to the exclusion of all others, while concurrent or coordinate jurisdiction is that possessed by the court together with another or other courts over the same subject matter, the court obtaining jurisdiction first retaining it to the exclusion of the others, but the choice of court is lodged in those persons duly authorized to file the action. Villanueva versus Ortiz. Are there certain types of cases or petitions where I can file it directly within the Supreme Court or file with the CA or file it with the RTC? Yes. And the best example is a petition for habeas corpus. The Supreme Court, CA, and RTC share concurrent jurisdiction to entertain petitions for habeas corpus. In effect, these are the instances when the Supreme Court, CA, and RTC exercise concurrent jurisdiction. There can also be concurrent jurisdiction among branches of a multiple sala court. Exclusionary principle. The court first acquiring jurisdiction excludes all others. Another principle is that may be relevant is the policy of judicial hierarchy. Territorial and extraterritorial. Territorial jurisdiction exercised within the limits of the place where the court is located. Extraterritorial jurisdiction exercised beyond the confines of the territory where the court is located. So, writs of certiorari, for example, prohibition and mandamus, are enforceable only within the region where the issuing court is located, while a writ of execution can be enforced even outside said territory. Elements of jurisdiction in civil cases. The word jurisdiction as applied to the faculty of exercising judicial power is used in different but related senses, which are the authority of the court to entertain a particular kind of action, 2. Administer a particular kind of relief depending on the issues raised, 3. It may refer to the power of the court over or to bind the parties, and 4. Over to bind the property, which is the subject of the litigation. In your study of criminal procedure, where you also studied the law on jurisdiction, we studied the authority of the court over the cases as determined by the imposable penalty, its authority to bind the accused and the prosecution, its authority to grant the relief, which is either acquittal or conviction, and over the place where the offense charge is alleged to have been committed. So there are what we call elements of jurisdiction in criminal cases, otherwise the proceeding will be illegal. These elements are jurisdiction over the subject matter, jurisdiction over the person of the accused, and territorial jurisdiction. Example, the case should be filed in the place where the crime was committed. Now, what are the elements of jurisdiction in civil cases? The following are the elements: jurisdiction over the subject matter, jurisdiction over the person of the parties to the case, jurisdiction over the rest, and jurisdiction over the issues. Now, what happens if a particular case, one of these is missing? The proceedings become questionable. The proceedings become void. Judgment is not binding. That is the effect of lack of jurisdiction. The proceedings are tainted with illegality and irregularity. Jurisdiction over the subject matter. Jurisdiction over the subject matter is the power of the court to hear and determine cases of the general class to which the proceedings in question belong. Banco Español Filipino versus Palanca. In other words, it is the jurisdiction over the nature of the action. In criminal cases, you have light, less grave, and grave offenses. In civil cases, we have such actions as actions for sum of money, actions not capable of pecuniary estimation, real and personal actions, action in rem, action in personam, and the like. This is what we call the nature or classification of the action. When a complaint is filed in court, the basic questions that ipso facto are to be immediately resolved by the court on its own are: what is the nature of the action filed? Does the court have authority to try and determine that class of actions to which the one before it belongs? Jurisdiction over the subject matter is not to be confused with the term subject matter of the action. Lack of jurisdiction over the subject matter is the proper ground for a motion to dismiss. This is broad enough to include the nature of the action. The term should not be confused with the terms subject or subject matter of the action, which refer to the physical facts, the things real or personal, the money, land, or chattels, and the like, in relation to which the suit is prosecuted, and not the delicate or wrong committed by the defendant. So if you talk about declaration of nullity of marriage, the subject matter of the action is the marriage of the parties involved, not any other contract. But the nature of the action is that it is not capable of pecuniary estimation. If it is for foreclosure of mortgage, the thing or subject of the action is the property mortgaged, in specific performance or rescission of contract. It is the contract involved that is the subject matter of the action. How is jurisdiction over the subject matter or nature of the action acquired? Jurisdiction over the subject matter is conferred by law, which may be either the Constitution or a statute, Tyson's Super Concrete versus Court of Appeals, and is never acquired by consent or submission of the parties or by their laches. This is a matter of legislative enactment, which none but the legislature can change. MRR Company versus Attorney Gen. It cannot be acquired by an agreement of the parties, waiver, or failure to object. So Congress plays an important role in the exercise of judicial power. Namely, it creates the rights which are sought to be protected or enforced. 2. It defines jurisdiction over the subject matter. Both are of course in the form of substantive laws. The law that confers jurisdiction refers to substantive law, not a procedural law. It likewise does not refer to an administrative order or circular. Malaloan versus CA. Suppose I will file a case against you in a wrong court. Actually, what you should do is file a motion to dismiss, or in criminal cases, a motion to quash. But you did not. Since you did not object, you did not file a motion to dismiss, you did not file a motion to quash. Did the wrong court acquire jurisdiction over the case? No, as we mentioned early on, jurisdiction over the subject matter cannot be conferred by silence of the parties or by waiver. Estoppel, or waiver, or silence, or failure to object cannot vest jurisdiction in the wrong court, because jurisdiction over the subject matter is conferred by law. And when the court has no jurisdiction, the court by itself, or motu proprio, has the power to dismiss. How is the subject matter or nature of the action determined? It is a settled rule that jurisdiction over the subject matter is determined by the allegations in the complaint, Baltasar versus Ombudsman, regardless of whether or not the plaintiff entitled to his claim asserted therein, Gokatono versus Gokatono. It does not depend upon the pleas or defenses of the defendant in his answer or motion to dismiss, Cardenas versus Camus. How do you determine the jurisdiction over the subject matter? It is determined by facts alleged in the complaint and the law in force at the time of the commencement of the action, Mercado versus Ubay. This is true in criminal cases, and civil cases. Say a case of serious physical injuries was alleged in the information filed with the CFI, which was then vested with jurisdiction over this type of cases. Even if the medical certificate attached to the records shows that the injuries are only slight, which falls under the jurisdiction of the municipal court, the CFI may convict for slight physical injuries. Jurisdiction was determined from the allegations in the information, People versus Okaya. In a civil case for collection of sum of money, where the complaint alleges that the totality of the demand is 350,000, the case is properly filed with the RTC, even if the defendant is able to prove that it is only 50,000. For jurisdiction over the subject matter is determined by the allegations in the complaint, not the defense or evidence presented. Exception to the rule that jurisdiction is determined by the allegations of the complaint. The general rule is not applied with rigidity in ejectment cases, in which the defendant averred the defense of the existence of tenancy relationship between the parties. In Ignacio versus CFI in Bulacan, it was held that while the allegations in the complaint make out a case of forcible entry, where tenancy is averred by way of defense and is proved to be the real issue, the case should be dismissed for lack of jurisdiction, as the case should be properly filed with the then Court of Agrarian Reform, now Darab, De La Cruz versus CA. In Ignacio and other ejectment cases, Salandanan versus Tizon, Concepcion versus CFI, where tenancy was the defense, the court went beyond the allegations of the complaint in determining jurisdiction over the subject matter and required the presentation of evidence to prove or disprove the defense of tenancy. After finding the real issue to be tenancy, the case says were dismissed for lack of jurisdiction. In Salmorin versus Saldivar, the plaintiff entered into an agreement with the defendant designating him as the administrator of a lot with a monthly salary of 150. The defendant allegedly did not comply with the terms of the agreement when he failed to till the vacant areas as agreed. This compelled the plaintiff to terminate his services and eject him from the lot. When the defendant refused to vacate the property, the plaintiff filed a complaint for unlawful detainer against him in the MCTC. In his answer, the defendant alleged the existence of a tenancy relationship between him and the plaintiff. Thus, he claimed that the case was an agrarian matter over which the MCTC had no jurisdiction. The court found that the plaintiff alleged the following: that he possessed the subject lot, that he instituted the defendant as administrator thereof, that the defendant failed to administer the subject lot by not having the vacant areas therefore planted, that for the defendant's failure to administer the subject lot, his services as administrator was terminated, that he advised defendant through registered mail to leave or vacate the subject matter lot, that the defendant refused to vacate the subject lot without jurisdiction. The court ruled that from its material allegations, the complaint concerned the unlawful detainer by the defendant of the subject lot, a matter which is properly within the jurisdiction of the regular courts. The allegation of tenancy in the defendant's answer did not automatically deprive the MCTC of its jurisdiction, because the jurisdiction of the court over the nature of the action and the subject matter thereof cannot be made to depend upon the defenses set up in the court or upon a motion to dismiss. Otherwise, the court ruled the question of jurisdiction would depend almost entirely on the defendant. Accordingly, the MCTC does not lose its jurisdiction over an ejectment case by the simple expedient of a party raising as defense therein the alleged existence of a tenancy relationship between the parties. It is, however, the duty of the court to receive evidence to determine the allegations of tenancy. If after hearing tenancy had in fact been shown to be the real issue, the court should dismiss the case for lack of jurisdiction. The court further stressed that a tenancy relationship cannot be presumed. There must be evidence to prove the tenancy relations, such that all its indispensable elements must be established. To wit, the parties are the landowners and tenant. The subject is agricultural land. There is consent by the landowner. The purpose is agricultural production. There is personal cultivation, and there is sharing of the harvest. All these requisites are necessary to create tenancy relationship, and the absence of one or more requisites will not make the alleged tenant a de facto tenant. All these elements must concur. It is not enough that they are alleged. The statement that jurisdiction is conferred by substantive law is not accurate because only jurisdiction over the subject matter is conferred by substantive law. Jurisdiction over the parties, issues, and rest is governed by procedural laws. No retroactive effect on law on jurisdiction. Jurisdiction being a matter of substantive law, the established rule is that statute in force at the time of the commencement of the action determines jurisdiction. RA 7691 has no retroactive application. UO versus CA. Why is jurisdiction substantive, not procedural? Because the law vests, defines, regulates authority or power.